This Honorable Court of Appeals is now in session.
Good morning. On behalf of Judge Stafford and Judge Golden, welcome to the Court of Appeals. If we should have any technical snafu as we proceed, stop and get them corrected and proceed. Will you, Ms. Lindsay, will you please call the case?
Pamela Estelle Harrison et al. Versus Shannon Nicole Harrison.
Okay, the appellant, are you ready?
I am, Your Honor. Thank you.
Okay.
Your Honor, if I could reserve 3 minutes for rebuttal, please.
Okay, 3 minutes.
Thank you. And again, I appreciate the court's indulgence, and I apologize for the delay. My name is Nathan Hunt, Montgomery County Bar. I represent the appellant Joseph Compton in this matter. A little background on this case. It is an interesting case, and it may be a case of first impression in the state of Tennessee as well. This case involves a same-sex marriage between Pamela Harrison and Shannon Harrison. The parties were married in Iowa in 2011. My client, Joseph Compton, agreed to donate his sperm to Shannon Harrison on 2 separate occasions, which resulted in Miss Harrison giving birth to 2 children, one child in 2014 and another child in 2015. The sperm donation did not occur in a clinic or a medical facility, and it was done privately between the parties. I believe there are 2 essential facts in this case before the court that are not at issue. One is there was no written agreement between any of these parties regarding—
Excuse me, am I correct in understanding that there's no transcript or statement of the evidence?
That is correct, Your Honor.
So that means the facts as found by the trial court are the facts that we have.
That's correct, Your Honor. And one of the main issues with that is when my client filed his intervening petition with the court to assert his parental rights in this case, the court made a ruling just based on the arguments of the parties, to which time I filed a motion to reconsider on behalf of my client because there had been no evidentiary hearing. My client had not been given the opportunity to produce any type of proof or testimony regarding this issue. The court again addressed my client's motion to reconsider and allow for testimony, denied it, and made a ruling without hearing from any of the parties regarding this issue. And that's the primary reason there is no transcript.
Regarding what issue?
Regarding the issue of whether my client would have any rights regarding these minor children.
Well, he did intervene. Wasn't there a hearing where parties testified?
There was prior to my client intervening in the action, Your Honor.
So he intervened too late.
Well, he intervened while the divorce was pending. There was a hearing. The divorce was pending for quite some time, and there was a hearing prior to my client becoming involved in this matter regarding some of the parental issues. But once my client intervened, the court granted my client's motion to intervene. They did not find that it was untimely filed. But after my client filed his motion to intervene, the court had a number of hearings where the attorneys argued the legal positions of the parties with this respect, but never allowed for any type of testimony or evidence to be introduced to support either party's position. And specifically based on the court's findings—
Let me ask you a question then, Mr. Hunt. Does that mean, are the facts stipulated here or what?
I'll try to answer that question, Your Honor. I believe the facts that are stipulated to is that there was no written agreement between any of the parties. I believe everybody agrees to that. And I think the other main fact that all the parties would agree to is that my client is the biological father of the children. It was his sperm that was donated that resulted in these 2 children being born. Those facts aren't in dispute.
Were there parentage tests done, or is that just the agreement of the parties?
That's the agreement of the parties, Your Honor. I do not believe there's ever been a DNA or paternity test actually performed for either of these children. That was just everybody's consent, including both of the Pamela Harrison and Shannon Harrison. I don't believe anybody disputes that the facts that resulted in these 2 children being born, which was that my client, Mr. Compton, donated his sperm, and that resulted in these these two children being born. That is not in dispute.
Has there ever been a determination of parentage or the signing of a voluntary acknowledgement of parentage?
Not to my knowledge, no, there's not.
All right.
There's not, Your Honor.
Are you asserting that there was some type of agreement or discussion regarding his involvement here?
Your Honor, and that's one of the main issues, which is why we requested that there be testimony in an actual hearing regarding this matter. My client had produced 2 sworn affidavits prior to becoming a party, and within those 2 sworn affidavits that were filed with the court, he indicated him wanting to be involved in the children's lives, and the fact that for a period of time he was involved in the children's lives until Pamela Harrison basically excluded him from that involvement. The trial court took one part of one statement in Mr. Compton's affidavit where he said he was not involved in the children's lives and used that to basically find intent that he was not going to be a parent for these children. But that was only part of the sentence. There was a because to that sentence, and it was because Miss Harrison had not allowed him to be involved in the children's lives. So really the only thing we have before the court as far as Mr. Compton is concerned in the way of any type of evidence are these 2 sworn affidavits. And in both of those affidavits, he consistently says that he wants to be a part of these children's lives. There was no express or no written agreement that prohibited him from being involved in those children's lives. And there was no agreement between the parties at all. But again, there was no testimony produced or no hearing allowed to determine that. The court just made that determination based on part of a sentence in a sworn affidavit of Mr. Compton. The primary issue before the court that the court found was that the artificial insemination statute essentially applied, and that there was no written agreement that needed to be performed by the parties, that basically you could look at the express agreement of the parties, as I've previously discussed, and that express agreement did not show that Mr. Compton wanted to be a father to these children. As set forth in my client's brief, clearly it would be my client's position that when you read the artificial insemination statute in conjunction with the other parentage statutes, it would require a written agreement signed by Mr. Compton to waive any parental rights he would have to these children. Essentially, that's
how do you get that? The legislature knows what it's doing in theory,
right.
and they required written agreements in some of the other circumstances, yes, but they didn't say require a written agreement here, did they?
They did not. They require consent. The best way to read the statute is it requires consent of the parties, Your Honor. And the issue there is the only way you can look at consent is you need to go to another section of the statute to define what consent is. And we looked at the adoption statute, which defines consent as requiring a written authorization and permission. However, to the court's point, even if you were talking about some type of express agreement, you would still need an actual evidentiary hearing to assess the credibility of the parties and what evidence could be produced about an express written agreement. And there was no hearing in this case to make any determination like that. And there certainly is not a written agreement between the parties. My client's affidavits clearly states he wants to be.
Mr. Hutt,
Yes.
are you saying that there was a express written agreement or an express agreement between the parties here?
As far as my client's ability to parent, no, Your Honor. My client is essentially saying sort of the opposite, which is he never agreed in writing or otherwise to not be a parent to these children or to waive his rights to be a parent to the children. He would state in his affidavits that he took actions to support his right to be a parent to those children.
But yet he never sought a judicial finding of parentage or signing of a voluntary acknowledgement of parentage.
Your Honor, so one thing that my client did before we filed an action to intervene in the divorce was a petition was filed in the Montgomery County Juvenile Court to establish my client as the father of the child. And an order was entered by the juvenile court establishing him as the father and setting forth a parenting plan. However, subsequently, Pamela Harrison intervened in that juvenile court action, and the juvenile court set aside that order They didn't dismiss that case. That case is still pending in the Montgomery County Juvenile Court. The juvenile court simply set aside that order and instructed Mr. Compton at that juncture to file a motion to intervene in the divorce action.
And the reasoning of the juvenile court judge was that once that divorce action in the circuit court was in place, the juvenile court lost its ability to make those decisions, right?
That is correct, Your Honor.
And isn't that correct law?
My client's position, Your Honor, was that this was juvenile court, at least in our county, addresses children born out of wedlock. Mr. Compton's the father. He was not married to the mother. So that was the appropriate court to address parentage of those children, because the biological father of the children and the biological mother of the children were not married to one another. So the appropriate place to file that is juvenile court to establish parentage and for a parenting plan. I believe the juvenile court's frustration may have stemmed from the fact of Pamela Harrison not being involved in that action. My client's position was she was not the biological mother of the children, and juvenile court addresses issues between biological parents. So that was my client's position. Interestingly enough, the juvenile court did not give a lot of instruction beyond instructing my client to file a motion to intervene in the divorce action. It didn't dismiss his petition in juvenile court, basically just set aside the order that was entered to legally establish him as the father, and did instruct Mr. Compton to proceed with intervening in the divorce proceedings.
Well, that would be natural, wouldn't it? I mean, wait and see what happened in the divorce proceeding. And if for some reason it didn't get to this issue, then the court would do it.
That's correct. I believe that's correct, John. I believe that's correct. My client, Mr. Compton, felt like an action needed to be filed in juvenile court to make sure he was protected in that regard as well, because there could be a situation where the divorce court said he was not properly before that court, could not intervene in that action. And then the issue may be, did he assert his rights in the proper court in juvenile court to assert his rights as a parent? So, Mr.
Let me ask you a question, Mr. Hunt. This divorce was eventually granted, correct?
It was, Your Honor.
And so what is the status of the parties and the children at this point in time? If we're backing up and taking an objective look at it, where are we?
The court, once the court dismissed my client's intervening petition, my client was out of the case at that point. Ultimately, there was a divorce hearing. The court divorced the parties and ordered a parenting plan. That parenting plan awarded the biological mother primary parent status for the children, but it did give the non-biological spouse parenting time with the children. So there's just a parenting plan in place between Miss Harrison and the other Miss Harrison, and Mr. Compton was excluded from any parenting time based on that order, Your Honor.
I realize your time is up, but I want to pose a question to you and you can answer it in rebuttal. Is there a place for your client in the schedule of parents here? Can you have more than two parents legally? I don't know the answer to that question, and I don't know that anything prohibits it, but I'll let you respond to that in rebuttal.
Very good. Thank you, Your Honor.
All right. It's time for the appellees. I understand you've split your time.
Yes, Your Honor.
Okay. Whoever wants to go first, please proceed.
I'll go first. I represent the biological mother, Miss Shannon Harrison. My name is Katie Klingard of the Montgomery County Bar. I have a lot of the same arguments as Mr. Hunt in this matter, that, my client was the children's biological mother. She birthed the children. The sperm was put into her. That was Mr. Compton's. There's no disagreement that he's the father or any other father out there whose sperm might have been donated. The parties were married at the time. Well, the Harrisons were married at the time. Our issue is that Miss Harrison relies singularly on the birth certificate statute, which is a part of the Vital Records Act, as you know. And it essentially terminates Miss Mr. Compton's right and diminishes my client's rights to the children as their mother. And this statute, it doesn't specifically reference parentage or the rights of the donor. There was some testimony. There was, one hearing, as the record reflects, in that Mr. Compton was not allowed to testify or have an attorney at that hearing. He also wasn't served with any of, this action by Miss Pamela Harrison. The adoption statutes, they're the ones that deal with the termination of parental rights and the process of adopting a child that a parent's not biologically related to. And as Mr. Hunt said, the adoption statutes do require written consent. Miss Pamela Harrison never attempted to adopt these children. No adoption was ever filed. She's never requested that Mr. Compton's rights be terminated. Our position in regard to the question of 3 parents is that Miss Pamela Harrison should not have any right to these children. That's Miss Shannon Harrison's, the biological mother's position in this.
Well, can you have 3 parents legally?
It's my client's position, and there's a step parent statute that provides for step parent visitation, and that maybe that's where Miss Harrison or one of the other, or Mr. Compton fits. I don't think you can technically have 3 parents, and so my client's position is that Mr. Compton would be the biological father, and obviously my client's the biological mother. And where that leaves Miss Harrison, I don't know.
Let me ask you a different question then. Let's forget about the statutory provision about providing the sperm and the contract. At common law, what right would Mr. Compton have as being the person who provided the sperm here?
Well, I think that, I think one of the problems in this case is that we don't know what his intent was in providing the sperm. Does
that make any difference?
I think it does. Yes, I know they were married. And I do think it makes a difference as to what the intent of the parties were in providing. And I do think to waive those important rights, and for my client to waive those important rights to have a child with someone who she may not have intended to, I think there should be a written waiver. And I think, common law, I don't know if it specifically.
And I agree with you. It should be a written waiver. It should be some kind of contractual agreement. But let's just say it's not in this case. And a person provides sperm to a donor, or a donor provides sperm, and a child comes into being as a result of that. Just from common law, does this person have does the donor, in this case, Mr. Compton, does he have any rights because he is the sperm provider? And we don't even be concerned about his intentions at this point in time.
Yes, I think he would have biological rights. A legal right to the children as a biological father.
So consequently, if he had rights, he had responsibilities as well. Would that be accurate?
Yes, but Miss Pamela Harrison has never asked that his rights be terminated in any way.
We're just trying to establish whether he's got rights right now.
Yes, yes.
And if he does, then the termination would obviously be the next logical question. But so you think at common law, because he provided the sperm without considering any agreement, that he had some rights?
Yes, without a written agreement.
Okay. Thank you.
Along with those rights, if he has rights, does he have obligations?
Yes, I think
So did he pay child support?
Yes.
He did pay child support.
No, oh, I'm sorry. I didn't hear your question. I thought you said, would he have to pay child support? Yeah, no, he has not paid child support. I think he's provided Miss Harrison with some support, as far as emotionally during this time, but I don't think he's actually paid child support, which, I mean, that would go to Mr. Compton would have to testify to that as well, at the trial court.
What about,
Oh, sorry, go ahead.
oh, I'm sorry.
Sorry.
Go ahead. What about the artificial insemination statute says that a child born to a married woman as a result of artificial insemination with consent of the married woman's husband is deemed to be the legitimate child of the husband and wife. Don't we have to read that after Obergefell in a neutral way such that it applies in this situation?
I cited a Tennessee Court of Appeals case, in re the adoption of male child. It specifically says that the names listed are not a finding of parentage on the birth certificate. The determination of who should be listed as the mother on the birth certificate is independent of the determination of who is the legal mother.
Well, this doesn't say it doesn't say anything about listed in the birth certificate. What I read said child born of a married woman, the result of artificial insemination with the consent of the married woman's husband is deemed to be the legitimate child of the husband and wife. And my question is, don't we have to read that in a gender neutral way after the U.S. Supreme Court marriage case?
Yes, I don't disagree with that.
So there is at least a presumption that the husband or the other Ms. Harrison would be the parent.
I think we're missing some definitions as to what artificial insemination and consent are.
Well, we have to figure that out, but consent doesn't say written, and artificial insemination doesn't say it has to be done by a doctor or in a hospital.
Those aren't defined clearly.
Okay, thank you.
I have one question. I know time's up, but I just wanted to follow up on what Judge Bennett was asking in a different track, and that is it your position that in a situation like we have here, where Pamela Harrison and Shannon Harrison were legally married, and the children were born subsequent to the marriage, that in order for Pamela Harrison to have any legal rights, that she would have to adopt the child that was born during the marriage?
Not if there was a written waiver. If there was a written waiver, no, I think that whenever you sign a written waiver waiving your rights to a child, then as a part of artificial insemination, usually you don't have, I don't think an adoption would be necessary, but in this case I do, because there was no written waiver. There was no clear agreement of the parties.
All right, thank you.
Okay, is Mr. Smith there?
Mr. Smith is no longer in the meeting. I do not know when he left.
We lost him.
I said we have a problem.
Well, let's, I suppose we need to wait a moment and see if he rejoins.
From when I first noticed he wasn't in the meeting anymore, because when I first noticed was about 5 minutes ago. So it's been at least that long.
Can we call him?
Ms. Lindsay,
Essentially.
are you there?
Yes, sir.
Can you call Mr. Smith and see what's going on?
Yes, I will.
Perhaps he'll rejoin us quickly, but maybe a call would be appropriate.
Certainly hope we haven't jinxed our lack of technology problems by talking about them.
Truly.
You can never talk about those things.
That would be accurate.
All right, since I have a phone call, potentially that's.
Hello,
Hello?
this is Greg Smith. I don't know what just happened, but I would presume that I have either waived my orals or am doing it by telephone.
We, if we can't see you, at least, we'll hear you. How about that, Mr. Smith?
Well, I've got the face for radio, so that'll work.
Well, Ms. Lindsay, are you there? She works
Yes, Your
the,
Honor. I was
yeah.
on the phone with his office.
okay, he's on the phone with us now, Ms. Lindsay, so I wanted to make sure you were here before we let him start so that you could run the clock.
We're ready.
Okay, is everybody all right with Mr. Smith being on the phone?
Absolutely.
Yes, Your Honor.
Okay. Mr. Smith, you may proceed. You have 8 minutes.
Thank you, Your Honor. May it please the court, Greg Smith, Montgomery County Bar. There's an old expression in East Tennessee where I was reared, a short pencil is better than a long memory. In this particular case, I have the luxury of not being one of the trial attorneys, so I have to look at the record to find out what happened. If the court will look at volume 2, page 219, which is the memorandum opinion and order, Judge Crozier says the following: based upon the testimonies of the parties, as well as Sherry Scott, Pamela Harrison's mother, and Bobby Hickman, Shannon Harrison's mother, an argument of counsel and briefs provided by both parties, an argument and brief provided by intervening petitioner Joseph Brian Compton, the court finds as follows. Respectfully, Your Honor, Mr. Compton intervened in the end of February 2019. The parentage issue, that hearing was done in May of 2019. Therefore, as an intervening party, he became a full part of this case. Why he didn't participate, I have no idea, because there's no appellate record. But there was a hearing, and according to the findings of the court, Mr. Compton was an intervening party. He was a part of the case, and he provided argument through a brief. I don't know why he wasn't present. After the court made its ruling, then there was a scheduling order to where Shannon Harrison attempted to include a rehearing on the parentage of the children. The court specifically struck that out. So there was 2 times when specifically the court had addressed this issue and said, no, we've had a hearing on it, we ruled, I'm not changing my mind. The court also made specific findings of fact, and the findings of fact from this hearing was a 10-page finding of fact conclusion of law. Since there's no transcript, this court respectfully needs to conclusively find that there were sufficient issues and findings and evidence to support the court's finding. As I say, the court specifically found that Joseph Compton was participating as of the hearing that is the main focus of this case. The court found specifically that the intent of all parties was that he would be a mere sperm donor, not to be an active father in these children's lives. The next thing that the short record shows, the parties were married in Iowa in 2011. Oberfeld, which interestingly hasn't been referenced up to this point that I've heard was decided in 2016. One child was born before the decision, one child was born afterwards. The child that was born after the Supreme Court ruled on that case, which originated out of Nashville, Abby Rubenfeld was the attorney for it. Pamela Harrison is on the birth certificate for that child. The reason she's not on the other child's birth certificate, Tennessee didn't recognize same-sex marriage, so they would not, prior to that decision, put her on the birth certificate. There was actions taken by both Harrisons to attempt to put these children and the parents on the birth certificates. There's a presumption, married parties, if they're on the birth certificate, there's a statutory presumption that they are the parents. So there was no need for an adoption statute because mom and dad, or mom and mom, were already there. The next point, the statute on artificial insemination has a presumption that as long as the parties are married and the non-biological mother knows that the biological mother is being artificially inseminated, there's a presumption of legitimacy in the marriage and in the parenthood. In this particular case, Pamela Harrison was literally going to Mr. Compton's house, getting a sperm sample, driving it back home to her house and the other Mrs. Harrison's house, inserting the sperm. Mr. Compton and Shannon Harrison never had sex. The insertion was actually done by Pamela Harrison or at times by Shannon Compton. That's part of what the trial court specifically made findings of fact on. The court made findings of fact that the children referred to Pamela as mommy and Shannon as mama, but there was no endearing nicknames for Mr. Compton, and Mr. Compton didn't even show up into the process until after a divorce was filed. To argue at the juvenile court that they just overlooked Pamela Harrison is a little bit respectfully disingenuous, because Mr. Compton had filed several motions, affidavits, and pleadings supporting Shannon Harrison seeking the children.
Mr. Smith, let me ask you a question.
Yes, ma'am.
Does Mr. Compton, and we won't even consider the statute on artificial insemination, but does Mr. Mr. Compton, as the sperm donor in this case, have any common law rights as it affects this case?
I think potentially it could. The problem here, though, is that there's a factual finding and a conclusion of law that there was no intent for him to be a parent, that he was a mere sperm donor. So, although that could have been potentially addressed, the fact that we don't have a transcript to see how or why, the court's finding of fact and conclusion of law that there was no intent that he be a father, I believe is conclusive on this court. And interestingly, on his motion,
I think Ms. Klingard said something similar here. Both of you seem to think that and believe that the law requires some kind of intent for them to want to be a father. Is there some basis for that? Something you're relying on?
the statute on artificial insemination, I believe, makes it clear that the mere fact, and ironically, back in my days at Cumberland 1,000 years ago, I did a law review article on artificial insemination, and the theory is, under the Tennessee statute, which applies, the parent that is inseminated is the biological parent. And an Oklahoma case, just like the Tennessee case that's before this court now, says that the non-sperm producing parent is not just a de facto parent, but a parent in actuality. So we believe, since the intent was found by the court that this was a mere sperm donation, it would have been the functional equivalent of going to a sperm bank, that if the person has made the donation, they no longer, for lack of a better term, have a dog in the fight. Now, interestingly, in the motion to reconsider the court's ruling, Mr. Compton made the following quote, which were his Freudian slip is showing. Quote, "There are 2 minor children born of the parties' marriage, Chevelle Marie Harrison and Stacy Estelle Harrison. Since they were born of the marriage, and even Mr. Compton acknowledges that, there's a presumption of paternity. The artificial insemination statute on top of that gives a presumption."
Sorry,
And the fact-
Mr. Smith, your time is up.
I apologize.
No, that was a fast 8 minutes. But thank you.
Thank you, sir.
Mr. Hunt, I believe you have about, 3 minutes?
Yes, thank you, Your Honor. Your Honor, I want to take the opportunity to address Judge Stafford's last question that I reserved for rebuttal. He had asked me basically about what's commonly referred to as a tri-parenting situation, which is more than 2 parents. To answer Judge Stafford's question, the law is going in that direction. Right now, there are 4 states that recognize a tri-parenting situation: California, Maine, Washington, and Louisiana. And the state of Vermont is also going in this tri-parenting situation as well. It's interesting, California specifically found that there could be more than 2 parents to a child, and all of those parties could have custody and child support rights or obligations, to answer one of the other judge's questions regarding those children. And that case also found that was being adopted because that is the growing trend is for non-traditional families. So when you have non-traditional families, you have issues like we have in the case before the court today, and you have to make accommodations for those non-traditional families. You cannot keep looking at just every parenting plan is going to be a 2-parent or a 2-party situation. And that's why multiple states have gone to this tri-parenting situation where you can look at having more than just 2 parents, and that all of those parties would have legal rights and legal obligations as it pertains to those children, not just 2 parties. Respectfully, I believe all states will go in that direction at some point in time because of Obergefell, which recognizes gay marriage and the fact that you do have a lot more non-traditional marriages and relationships being recognized by the court now than you did previously.
Do you need a statute to go in that direction?
Your Honor, 2 of those states have actually adopted statutes in that regard. California did adopt that statute in 2013 that I just described, but it was based on the finding of a court case in California, but then they did specifically adopt a statute that addressed what I'm referring to as the tri-parenting situation. So at some point in time, there probably would be a statute that would need to be adopted, but states are starting to adopt those types of statutes. I certainly have not seen anything in Tennessee that would specifically exclude a tri-parenting situation. And I believe that's why courts are adopting those statutes, is to specifically recognize the rights to more than 2 parents or 2 parties to a child. And that may be the situation where we're going in here. I certainly don't think it's excluded. I would present that it could probably already be done by agreement in the state of Tennessee. Obviously, that's not what we have here, but I believe the law is going in that direction. And there are states that are certainly recognizing legally that type of situation. And I know I just have a few seconds. I would just state that intent is not necessary here. You can look at the definition. It requires written consent of the parties. Thank you.
Thank you. Thanks to all of you. We appreciate your thoughtful arguments. And you've left us with quite a bit to think about.
Thank you, Your Honor.
Thank you, Your Honor.
Ms. Lindsay, would you please recess the court?
This Honorable Court of Appeals is in recess until 11 o'clock.
Thank you, folks.
Take care.